Chapter 2. Contract Law. Contract law is a fundamental pillar of business activity because almost all commercial transactions are based on legally binding agreements. The core principles of contract law emphasize that a valid contract is formed through mutual agreement, consideration, or exchange of value, legal capacity, and a lawful purpose. Business law scholarship highlights that contracts function as instruments of legal certainty, risk allocation, and protection of the parties' reasonable expectations in commercial relationships. Contract formation. In general, contract formation requires three main elements. 1. Offer. 2. Acceptance. 3. Consideration. An offer is a clear and definite statement of intention by one party to be legally bound if the offer is accepted by another party. In business practice, offers may take two forms: express offers and implied offers. An express offer is explicitly stated, either orally or in writing. Examples include a written contract, an email proposal, or a formal agreement document. An implied offer, on the other hand, arises from actions, conduct, or circumstances that objectively demonstrate an intention to enter into an agreement, even if no explicit words are used. Business law literature emphasizes that the existence of an offer is assessed using an objective standard, namely, how a reasonable person would interpret the statement or conduct. Once an offer is made, a contract is formed if there is valid and unconditional acceptance. Under the mirror image rule in common law systems, acceptance must exactly match the terms of the offer. Acceptance must also be communicated to the offerer. In addition, consideration is an essential element in certain legal systems. Consideration refers to something of value exchanged between the parties. It may consist of money, goods, services, or a promise to do or refrain from doing something. Without consideration, a contract generally lacks binding legal force, except in specific situations recognized by law. Contract validity. The validity of a contract depends on the legal capacity of the parties and the legality of its object. The parties must have the legal capacity to enter into a contract. This means they must not be minors, under legal guardianship, or acting under coercion or undue pressure. Furthermore, consent must be genuine. A contract may be invalid if it is formed due to misrepresentation, fraud, undue influence, duress. The purpose of the contract must also be lawful. Agreements that violate statutory law or public policy are considered void. Although contract law recognizes the principle of freedom of contract, this freedom is not absolute. It is limited by public interest considerations and mandatory legal norms. Breach of contract. A breach of contract occurs when one party fails to perform its contractual obligations. There are different types of breach. Material breach, a substantial violation that undermines the main purpose of the contract. In this case, the non-breaching party may have the right to terminate the contract and seek damages. Minor breach, a less significant violation involving secondary obligations. The injured party may still claim damages but cannot terminate the contract. Anticipatory breach occurs when one party clearly indicates, before performance is due, that it will not fulfill its contractual obligations. In business contexts, distinguishing between these types of breach is essential because it determines the legal remedies available to the injured party. Contract enforcement. Enforcement is a crucial aspect of contract law because it determines the effectiveness of agreements as legal instruments. Courts or arbitral tribunals may grant various types of remedies, including compensatory damages, monetary compensation for actual losses suffered, consequential damages, indirect losses that were reasonably foreseeable at the time of contracting, specific performance, a court order requiring a party to fulfill its contractual obligation, rescission, cancellation of the contract, restoring the parties to their original positions. Business law scholarship also emphasizes the importance of risk management clauses in commercial contracts, such as limitation of liability clauses, liquidated damages clauses, dispute resolution clauses. These provisions serve as strategic tools to minimize legal uncertainty and manage commercial risk effectively.
Okay, see you on the top.
Yes.